At the core of human experience lies a remarkable gift: our capacity for ingenuity. It is a quality that sets us apart, enabling us to imagine, innovate, and shape the world around us. Human ingenuity is the embodiment of our creative potential, a force that drives progress, ignites change, and propels us towards the future filled with endless possibilities. It is this relentless pursuit of discovery that has led to breakthroughs in science, technology, arts, and culture, forever altering the course of human civilization. In recognition of value and significance of human ingenuity, the need to safeguard and encourage such contributions by providing creators and innovators with incentives and rewards for their efforts, the idea of intellectual property rights have emerged. With its origins dating back to ancient times, today intellectual property rights are codified in national laws and international agreements. With the same human ingenuity making technology ever more powerful, legal protection of intellectual properties has become even more complex and important. Today, we will learn about this very important area of law practice: intellectual property law careers, and how the current era of artificial intelligence and generative AIs will impact this legal field. This is Career Calling, and I'm your host, Pratibha Pandit. My guest today is a veteran IP trial lawyer, an adjunct professor of law, and a technologist who has worked on artificial intelligence in its early days, Mr. Fabio Marino. Mr. Marino is an experienced intellectual property trial lawyer that focuses his practice on high-stakes patent, trade secrets, and copyright cases across the United States, with an emphasis on computer-related technologies and arguing appeals at the federal circuit as a partner at law firm Womble Bond Dickinson LLP. He currently teaches an intellectual property litigation class at Santa Clara University School of Law and coaches the University of California, Berkeley teams in the Giles S. Rich Patent Moot Court competition. Mr. Marino will share with us intellectual property legal careers, what it means to be an IP trial lawyer, and how the landscape of intellectual property legal practice will change with the increasing popularity of AI technologies. Hi, Fabio. Welcome to Career Calling.
Thank you. Glad to be here.
It's a very interesting times to be talking about intellectual property, given everything that's happening in the technology industry right now. Let me start with the basics. The definition of intellectual property, if I see, is a work or an invention that is the result of someone's creativity that someone has a right to or can obtain a copyright or a trademark. How would you, from a legal standpoint, define intellectual property, and what are the legal practices around it?
Okay, that's a very good question because the term intellectual property is used across the world with different meanings and different scopes. In the United States, it's basically a group of rights that have been recognized under the law. The U.S. Constitution, in fact, provides the authority to the U.S. government to issue patents to inventors and copyrights to authors. So those are the two fundamental types of intellectual property. Over the years and both through legislation, both at the state level and at the federal level, we've recognized other forms of intellectual property. For example, trade secrets, which are usually and traditionally have been state property rights. But recently, like about 10 years ago, they also were legislated at the federal level. So right now, we have a federal trade secrets protection and state trade secret protection. And then obviously, in addition to the fourth branch that primarily makes up intellectual property, is trademarks. So they're also federally registered. And they cover a different aspect of the human invention and development of value process.
When it comes to legal practices, what are the branches just specific to the intellectual property? I've seen a different titles like patent lawyer, you are an IP trial lawyer. So what are the different branches?
Yeah, so we basically talk about intellectual property lawyers, so all of us who deal with intellectual property laws. Within those, there's two primary differentiations. Litigators like me, people who go to court, who enforce authors, inventors' rights. And then there's people that work on procuring the rights in the first place. For example, when you use the word patent attorney, that technically designates a lawyer who is registered to practice in front of the U.S. Patent Office, and therefore represent an inventor in obtaining protection for their invention. That's the biggest distinction between, basically lawyers that work to procure intellectual property rights and lawyers that work to enforce them, to litigate. That are the two main branches. And in terms of the various types, as we discussed briefly earlier, you have patents, you have copyrights, you have trade secrets, you have trademarks. Those are the most commonly recognized intellectual property rights. There is a few other things that intersect with other branches of the law. Also, for example, there are IP licensing attorneys. Those are attorneys that basically write contracts, very different from what I do, but they are specialized in writing contracts that assign intellectual property rights from one party to the other. So they are also IP attorneys at some level. And then there are things like the right of publicity, which can be a form of intellectual property right. And that doesn't exist at the federal level. It exists at the state level. California, of course, in Hollywood and Silicon Valley tends to be quite at the forefront of that. And in fact, I was just speaking to somebody else about deep fakes. That's something people have probably heard recently. And it turns out that the main way to attack a deep fake is through the right of publicity. If in fact the person who's being fake is a famous person. So that kind of covers the various.
What is interesting about this field is on one side, you need the knowledge about the laws around intellectual property. And then on the other side, either to be able to procure or defend, you would also probably need good understanding of the intellectual property space itself. Like, for example, if it is a technology product, you would need the technology understanding. So how does that work? Can an IP lawyer or any legal practices, do they also specialize in a specific industry? Is it like your technology IP lawyer or entertainment, music? Is it like that?
So in the patent field, actually, to be a patent lawyer, you also have to have technical training. And so the patent office requires both a certification that you're a lawyer and also a certification that you understand certain core technologies that are recognized to have the qualification of patent lawyer. So, for example, I have a California bar number and I have a patent bar number because I satisfied both of those requirements. But beyond that, even within patent lawyers, we basically subdivide ourselves in multiple groups depending on the technologies we're more well-versed in. And at the highest level, we would talk about biotech lawyers versus high technology lawyers. So I'm a high-tech lawyer and I can deal with anything having to do with a computer in some way or another. I would not do a case on biotech. You have a case about pharmaceuticals, if you have a case about genomes actually to some extent I understand because heavily computerized. But drug, for example, the whole drug industry is regulated and it has its own special statute. It's called the Hatch-Waxman statute. And so the whole area of litigating patent infringement with pharmaceuticals is a whole specialized branch. And typically the lawyers that practice in that space have PhDs, typically in pharmacology, or at least in a related area like chemistry and so on.
So in terms of education, specializing in these fields, Does it happen like first you get a law degree and then you get in these spaces, or is it the other way around usually? You either
Typically the other way around.
the way around, okay.
So we recruit engineers and scientists to go to law school.
Oh,
And we were talking about your alma mater, Santa Clara. I've been involved with the iTech Law Institute at Santa Clara for the past 25 years. And one of the goals of the iTech Law Institute is to get engineers and scientists interested in law school and then specialize in intellectual property once they get into law school.
I saw you have a bachelor's and master's degree in computer science, and you also started off in the technical field. Did you always envision going into legal field? How did you get attracted to this field?
No, I didn't envision it. So when I went to graduate school, I thought I was going to get a PhD in computer science.
Uh-huh.
And then I met with a company that was actually in its day the leading company in artificial intelligence, and they were developing products in the same field I was doing my research. And so I went to work for them to develop AI systems back in the early 90s. And then as I was working as a consultant, one of my friends who was a practicing lawyer told me about intellectual property, and I found it very interesting because as a consultant, I spent a lot of my time explaining technology at a high level to executives to enable them to make intelligent decisions about what systems to develop. And my friend was like, well, that's pretty much what intellectual property lawyers do. They explain to executives, how to use, how to develop their products. And then obviously people to court, you do the same thing with judges and with juries. And that turned out to be true. I enjoy very much the process of teaching technology to people who are not technologists and to do it as a trial lawyer.
That's amazing. Now, I've seen lawyers, IP lawyers within a big organization, like companies, right? It could be technology companies and stuff like that. And also lawyers in the law offices, right? Like you are. So what are the career paths? Like, are these the only two, or what does the typical career path look like here?
So there is basically three areas, right? So you have, as you said, in-house lawyers, so lawyers that work for companies. You have law firm lawyers that work for law firms. And then you have lawyers who work in the public sector. So the ones judges, the ones who work for the government, and so on and so forth. And actually, it's none of those groups really predominates over the other. It's depending on the region. It's a third, and a third, or maybe in some region in DC, about half of them at least are working for the government. In other areas, there's probably more trial lawyers. But generally speaking, all three are actually very frequent directions that people can take. And the practice is very different, of course, because when you work for a company, you basically have one client, the company. Of course, you have many internal clients within the company, so that people interact with daily, but you have essentially one client. When you work for a law firm, obviously you have a multitude of clients. And in my case, as a trial lawyer, often different clients all the time, right? Not a lot of companies get sued for patent infringement all the time. There are a few, but most of them do not. So I actually find it very enjoyable to work with clients, for the first time, right? And then obviously in the public sector, when you work for the government, in a way you have one client, but in a way you have everybody as a client, right? So each one is very different in terms of the practice and the rewards that it offers.
Is the career ladder also different in each of these? Where does one start and how do they grow?
So traditionally, if you went back to when I graduated from law school some almost 30 years ago, basically most people would go to a law firm and then after a couple of years of training would move on to in-house or to the government. Over the last several years, though, that has changed, particularly in Silicon Valley. So now companies recruit directly from the law school. So it's not unheard of today to see a lawyer who's been always in-house. And it's not unheard today to see a lawyer who's been always working for the government. So it's no longer true that everybody goes through the law firm training environment to everywhere. The one thing that's very different is that when you work for a law firm, it's one of the only industries where you walk in the door as an employee and you can retire as an owner, right? Is what differentiates that practice from everything else, right? If you work for a company, you're always going to be an employee. But if you work for a law firm, after a number of years, if you do well, you can become a part owner and then grow into the firm.
What is the typical day-to-day activities that IP lawyer, trial lawyer, we can focus on trial lawyer.
So let's talk about the difference between the trial lawyers you see on TV like Perry Mason and what we actually do, right? When you watch TV shows, it looks like we go to court every day.
Exactly.
That does not actually happen. It would be very nice because that is a very enjoyable part of the profession, but it doesn't really work that way. So IP litigation is part of what we consider complex litigation. And complex really means that the cases tend to be very complex and last for a long time. So the average patent case, for example, takes about 3 years to go to trial. And so you can think of the fact that over the course of 3 years, if we don't go through all the preliminary steps for a trial, then the trial at the end will be maybe a month, maybe a month and a half. But so that gives you a sense of what percentage of the time is spent in trial versus preparing. Of course, there's many court appearances before the trial. So I'd say it's probably somewhere between 10 to 20% of the time that we spend in court or in some sort of, adversarial proceeding that people would recognize as what they see on TV. But the other 80% is basically preparation for all those things to happen.
Now, in the part of this 3 years, how much of it is about, understanding the law, or how much of it is about really digging and understanding this technology? Like, is there a ratio of it?
So you have to think about it this way. So everything is done in preparation for trial. And at trial, what happens? You have a very limited amount of time, usually measured in hours. And usually not a very large number of hours. It's something like 40 over the course of multiple days, of course, where you have to present your entire case to the jury. The jury is a group of, anywhere between 6 and 12 people who have no connection with the law necessarily or with the technologies, to teach them everything about the case and enable them to make an intelligent decision, or at least a decision they feel comfortable making. And so a lot of what we do before is to prepare for that, both in terms of acquiring the evidence, acquiring the proof for what we're going to demonstrate. It's not just going into court and telling them a story. We have to show them evidence. And a lot of the law when it comes to trials is about developing evidence. So we question witnesses, collect documents, review all of that. We work with experts, and experts can testify at trial to explain to the jury things about the science that couldn't be understandable otherwise. And then the judge and the other side get to go through all of that in advance and decide, there are objections that can be raised, and the judge then has to resolve those objections. And that's all because we have a jury system. In other countries, that really doesn't happen as much because we don't have they don't have jury systems. And so the lawyers go in, argue in front of the judge, and then they come back, next time that the judge has done it. And it also takes 3 years, but they do the trial over the course of 3 years. Here, we actually do it all at once because we can't take the jury away from their daily lives for 3 years. So we do all of this preparation in advance, and then we bring in the jury and we try the case.
It's so interesting being able to explain some of these complex technologies to jury. When explaining law is hard itself.
Yeah, in fact, we're not allowed to explain the law, which is an interesting concept. Because otherwise, you have two different lawyers explaining two different versions of the law to the jury, right? So the judge is the one who actually explains the law to the jury. So if you do a trial, there will be a section of the trial where the judge gives the jury instruction. And we obviously work with the judge to prepare the instructions. Largely, they are the same across different cases, but they get customized for each case. And so that's literally how the law gets explained to the jury. But everything else we need to put together. And then obviously what we do as lawyers is we help the jury apply the facts that we can present in the form of evidence to the law and tell them how we think they should decide in our client's favor, of course.
Mhm. So the communication part also plays a very big role, right? Somebody to be able to explain the complexities. What are some of the traits or personality and skill wise that are important to be successful in this field, in your opinion? You also teach trial law.
So being a teacher helps. So one of my large trials, I had a jury that was for 6 aides professional teachers. And so the first thing I told them at the beginning is that I was very intimidated because they're all professional teachers. I didn't tell them I also teach, but I told them I was going to try to do my best to explain what I had to explain for purposes of the case. But that's really the way to think of yourself. And you have to think of yourself as a good teacher, not somebody who's going to sit there and teach in an authoritative way, right? You have to, I always think about it as, I think of myself as one of the jurors, but one who's able to ask questions. Because that's the hardest part about being a juror. You're sitting there for days on end and you can't ask questions.
The question, yes.
That's allowed to listen. Now, some judges now allow the jurors in very limited circumstances to actually ask a couple of questions at some point, but it's very few. And so really part of the role that we as lawyers play, and sometimes the judges do the same thing, is we actually ask the questions really on behalf of the jury to the various witnesses. So the way we present is we'll put a witness up with obviously somebody who knows a piece of the story, and we're allowed to ask them questions. And they're always geared towards the jury understanding what that person knows that is relevant to the case.
Interesting. From the law degree perspective itself, to be in the IP space, is it common to have JD or it is expected to have the master's or the doctoral program? How do those play a role and where do you start specializing?
So to be a lawyer, you have to get a JD and you have to pass the bar. Now, there are professionals that prepare patent applications and can, in fact, represent inventors before the patent office who are not lawyers. So if you pass, and the exam is the same. So if you pass the patent bar and you're not a lawyer, you become a patent agent. You still have to have the technical background. So I'm sure, if you work for a technology company in Silicon Valley, you probably know people who are patent agents, because there are both patent agents in firms and there are patent agents in corporations that work just on the obtaining the patent piece. But if you want to be a lawyer, you have to go to law school, you have to get a license. In terms of the technical degrees, generally speaking, an advanced degree is not required for engineers, but it is required for scientists, particularly in the pharmaceutical space. In my experience, most of the practitioners in the pharmaceutical space have a PhD of some kind. It's not a requirement, but that's what I had seen.
In other fields, let's say in engineering or any other field you take, undergrad is where they'll keep it slightly generic and they start specializing when they go to graduate degree and then the doctoral degree. How does it work in the law degrees? Like JD, and you can still do ML, right? Master's and then doctoral.
It's very rare that people do masters in law. There is such a thing as a master's in law. There is also a doctorate in law that you can get. Basically, nobody does it. It's pretty rare. Most of the masters of law students tend to be foreign law graduates who then get a master's in the US so that they've had some legal training from the US law school. That's been my experience. Where you really get the specialization is in practice, usually in the firm. So when you join a firm and you typically start joining while you're still in law school, so our usual hiring process involves bringing students in their first or most likely the second summer in between the 3 years of law school. And then they start working with different groups, and we kind of start deciding, which ones seem more interested in which area. And over the course of the first couple of years of practice, that's how you develop the specialty within law.
Mhm. Makes sense. Now, coming to what is happening in the technology industry right now, there is so much changing in the sudden outburst of the AI and generative AI. And on the other side, there is this whole content economy where the lines are getting blurred, right? What is original creation versus who is creating from where and where is getting used? How do you see this affecting the legal field and the IP law and in your field, trial lawyers?
Yeah, it's actually kind of interesting. So obviously AI is my background. So I
Mhm,
have some precise thoughts about it. In fact, I actually did develop some generative AI some 30 years ago. So it's not,
Oh,
so what has really changed in AI is not so much the algorithms, because quite frankly, a lot of the algorithms were defined a long time ago. It's the access to computing power. Just to give you an example, I did my master's thesis, which is actually a PhD thesis, but I was going out to work, so I had to call it a master's thesis. I had to use a supercomputer called the connection machine. It
mhm,
was housed in a whole huge conference room at UCLA. Today, my iPhone has the same computing power, basically, as
mhm,
that computer 30 some years ago. So that's what has really happened. So we
mhm.
now have availability of massively parallel computers in our hand. And that has made the applications obviously a lot more accessible to the public. I do think that language models, of course, making a big step forward. There was actually an expert system developed in the 60s that could carry on a conversation with a human, and about 80% of the humans could not tell the difference.
Mm.
So it's not that new of a concept. But of course, today you can backfeed the internet, right? Or at least the World Wide Web into that language model.
Mhm,
Actually, one of my friends is also very interested in AI, just did a very unique experiment. It asked ChatGPT about the results of game 3 between the Lakers and the Warriors that was played last Saturday. And he got a very nice article that unfortunately got the score wrong, identified several players that had not been on the Lakers for about 3 years as being major contributors and so on and so on. But if you read the article, it was totally believable. It was
mhm,
just like any article you get on the newspaper. So that's both a great thing and a cautionary tale, right? Don't buy everything ChatGPT will tell you. Not
Yeah.
necessarily true.
Yeah.
Sounds really good. Sounds like a person wrote it, but there is no, truth check on it. So I do think AI can provide very powerful tools. For example, one of the problems I encounter all the time, I'm actually working with 2 technology companies right now to harness the power of this technology, is we get this huge amount of data when we go into discovery, right? So it used to be in a big case, you get, say, 200 boxes worth of documents. And a person can go through 200 boxes worth of documents and read them in a week, 2 weeks, maybe a month. Today, what we get is the equivalent of 3 buildings of documents, okay? It's all electronic, including like all of the emails for the
Oh,
people involved going back maybe 10 years. It's impossible. I mean, it's theoretically possible, but economically impossible for anybody to go and read everything. So can you imagine the power of having an AI model go through that and tell me when I had the interesting article, interesting emails written by this person to this other person on this topic and get it back within 30 seconds. So that's one obvious thing we can do. In the field of writing contracts, which is a huge part of what in-house lawyers do, obviously you can write a model that will spit out a fairly well customized contract for a sale you're making to a customer that still will need to be reviewed by a human, but you're going to start with a pretty well customized draft. So we are all working on figuring out ways to make it useful. It will impact the practice from that standpoint. There are people who are playing around with writing legal briefs with AI. It's kind of like how many Shakespeare words we can get from an AI, not many original ones. So that's a little harder. We may be able to get drafts on some things. There is, for example, an area where we write a legal brief, we need to explain the law in a certain area. So those are fairly standard across the board. So I can see a role for AI in developing that kind of writing. But at the end of the day, the arguments are still probably going to have to be generated by humans. There is a lot, and it's going to replace the more mundane parts of the practice.
What about the complications that will emerge in defending the cases? For example, like things like Copilot, where you can take the code from somebody else. The lines are getting blurred there too of, whose creativity
But
it is.
Copilot is getting sued, and there's a lawsuit already going on. I was actually reading one of the orders from that case earlier today. But yes, that's problematic, right? So the AI has to be controlled. And that's why, for example, for that project that I was telling you about dealing with the discovery, we're not allowed to just feed the discovery into a regular ChatGPT kind of model. We have to develop a proprietary model that's limited to just that universe of document. Copilot could work that way, right? So I think a company could develop a private version of Copilot reusing their own code, and that will be fine. The current version is getting code from all over the place, and that creates a whole bunch of legal issues. In fact, I think it's going to keep a lot of lawyers busy for a while because, of course, if you reuse somebody else's code without permission, that's called copyright infringement.
Yeah.
And interestingly enough, in the case that has been filed against Copilot, they didn't allege copyright infringement just because it was unwieldy, right? Because it could grab any code that's out there and copy it without permission. And one of the things you have to do when you sue somebody for copyright infringement is identify the copyrighted work that's being taken. So in the actual lawsuit, the first lawsuit that was filed, which was a class action lawsuit, they brought up all sorts of other claims that they could without actually inserting copyright infringement. But we all know that copyright infringement is a big issue there. So,
okay, going to be interesting few years.
One thing that's always been common to intellectual property law is always that the law is trying to catch up to the technology, not the other way around. Right? So technology creates a new problem, and the law then tries to fix the problem. And there is always about a 10-year gap between when the problem first arises and when the law figures out a solution.
Interesting. So for somebody who is starting out now in this field, what would be your advice given the changes that are happening? What should they be expecting?
So as an IP lawyer, I think it's usual things, right? Know the technologies. But for example, I would learn how to use ChatGPT really well. Because like in most things, like garbage in, garbage out. If you ask the wrong questions, you're going to get the wrong, not very useful output. But I think there is actually a legal skill that's going to get developed for lawyers who are really good at asking the right questions of the language models that they're interacting with. And that will be a very valuable skill, particularly for younger lawyers, right? So in our profession, what I see time and time again is the younger lawyers that come in may not know the law as well, but they usually know the technology better than we do. And so this is just another example of that, right? I think we're going to have associates in a couple of years who are going to be able to generate really good work using the language models of the day, because those are going to get a lot better too in the next few years. And that's going to become a very important part of their job. Just like learning how to do legal research on a computer was a big deal when I was coming out of law school, because all the older lawyers were doing it with books.
Interesting. Thank you, Fabio. It was very interesting information. Thank you so much for sharing your knowledge and appearing on the podcast. Thank you. That is Fabio Marino, a veteran IP trial lawyer and an adjunct professor at Santa Clara University School of Law. For more information about IP laws and legal practices, please check the description section of the YouTube video. This is Career Calling, and I'm your host, Pratibha Pandit. Thank you for tuning in.